Thank you so much. Really excited.
All right. Good morning, good afternoon, good evening to everyone based on wherever you are in the world. Welcome to this illegal roundtable on advancing climate action and collaboration through conciliation, hosted by the International Council for Commercial Arbitration and the Climate Change Council. It is my honor to introduce our chairs for today. First, we have Advocate Catherine Amirfar, co-chair of Debevoise International Dispute Resolution Group and the Public International Law Group, who's a distinguished legal professional specializing in public international law, international commercial and treaty arbitration, and complex international commercial litigation. With over 20 years of experience, she has argued before federal and state courts throughout the United States, the International Court of Justice, and arbitration tribunals sitting around the world. She has deep expertise in representing states, international organizations, and non-governmental organizations. Thank you so much for joining us. And of course, her co-chair is Dr. Annette Magnusson, co-founder of the Climate Change Council, who's an independent expert and consultant on international climate law, international investment law, and arbitration, and the role of lawyers in the climate transition. She also holds more than 25 years of experience in international law and was Secretary General of the Arbitration Institute of the Stockholm Chamber of Commerce. Thank you so much for joining us today, and I'm handing the stage to you.
Thank you very much. It's really a pleasure to be here. Good afternoon, everyone. We're thrilled to come and be able to be with you during COP29. So together with Annette, we are going to be focused on really a blue ribbon panelists, and we'll get to introductions in a moment, around the Paris Agreement Conciliation Annex. So I wanted to start with some table setting and then hand it over to Annette for introductions, and then we'll get the panel kicked off. So we really are focused today on Article 14 of the UNFCCC, as well as Article 24 of the Paris Agreement. And under those particular articles, the disputes concerning the interpretation or application of these foundational instruments in the context of climate change are to be settled through negotiation or any other peaceful means chosen by disputing parties. If negotiations fail, however, and the parties have not previously agreed through written declarations to submit disputes to the ICCA, it provides that, or arbitration, it provides that the dispute shall be submitted, and I'll quote it, at the request of any of the parties to the dispute to conciliation. So conciliation is obviously the concept is going to be a focus of our discussion. And under the UNFCCC and Paris Agreement, there is the further language, and again, I'll quote it, that additional procedures relating to conciliation shall be adopted by the conference of the parties as soon as practicable in an annex on conciliation. And that's really why we're here today. To date, few states have made declarations consenting to resolve their disputes through either arbitration or before the ICJ, making conciliation the standing default method of dispute resolution for many states. Now, despite this, these contemplated additional procedures and the annex on conciliation have yet to be adopted. So to address what we perceived as a gap, in February 2023, the International Council for Commercial Arbitration, or ICCA, convened a world-leading blue ribbon panel of experts in the fields of dispute resolution and climate change to develop such a draft annex for the consideration of states parties. And this is exactly what today's panel addresses, this initiative, the role it could play in advancing climate action and collaboration. And we'll discuss why conciliation may be well suited indeed to climate change disputes and the context, methodology, and some key considerations of the draft annex. And as we'll talk through with these amazing panelists, we'll talk about inclusiveness, trust building, strengthening the parties' relationships, while at the same time giving effect to peaceful resolution of climate change disputes. So with those introductory remarks, let me just hand it over to my colleague and co-conspirator, Annette Magnusson, who's going to introduce the panel. Annette, over to you.
Thank you, Catherine, and hello, everyone. Thank you for joining us for this session here today. Before I introduce the panel, I would also like to thank the Climate Law and Governance Initiative and its partners for organizing this conference here today and to allowing us to contribute to the mission of the Climate Law and Governance Initiative through today's discussion. As you have heard from Catherine, after months of drafting and extensive consultations with stakeholders, the ICCA panel of experts has finalized the first draft of the Draft Conciliation Annex. And this draft consists of 25 articles that set out a proposed procedure for disputes submitted to conciliation under the Paris Agreement. The draft annex is also accompanied by a commentary explaining the basis for the text and the relevant factors for each issue that is presented throughout the draft. And this draft reflects the significant contributions both by states but also from non-state stakeholders throughout the process. Throughout the process, the ICCA panel of experts has consulted the stakeholders through targeted outreach to 87 stakeholders seeking written comments on the draft annex, and 4 briefings with state representatives to foster discussions on the draft annex and its key features and provisions. And states and non-state stakeholders have shown great interest in the draft annex, for which we are very grateful. And the panel has carefully considered all the comments that have been received and the questions received, and revised the draft annex accordingly. And we hope that the draft annex will complement existing dispute avoidance and implementation mechanisms as set out in the Paris Agreement. And in this way, progress towards global climate-related objectives. So with this, we are very pleased to welcome our distinguished panel who will be taking us through this discussion here today, which I am convinced will be very interesting. And we are joined by members from the ICCA panel of experts. So Makane, Moise, Mbengue, Toby Fisher, and did we have Laurence Boisson here? Yes, Laurence Boisson. Yes, lovely. Yeah. So Makane is a professor of international law at the University of Geneva, where he teaches international environmental law, climate change, and international law, among other subjects. He is also a member of the Committee of Legal Experts for the Commission of Small Island States on Climate Change and International Law, and serves as president of the African Society of International Law. Thank you for joining us. Laurence is a professor of international law at the University of Geneva. He has written extensively on climate change and environmental law issues, and has advocated for a universal understanding and language to tackle pressing environmental issues. Laurence served as secretary for the preparatory work on the UNFCCC. Thank you for joining us, Laurence. Toby is a barrister at Matrix Chambers in London, and he has also served as deputy director at international law for the New Zealand government, where he advised on international environmental law, law of the sea, and other issues. Toby led negotiations at the UNFCCC climate change conferences and at the International Seabed Authority and other multilateral fora. Thank you, Toby, for joining us. We are also very grateful to be joined by Christopher Bartlett, who serves as advisor on loss and damage for the government of Vanuatu. And Dr. Bartlett has written dozens of climate policy briefs and managed the implementation of multiple national climate change projects. Very nice to have you with us today. And finally, we have with us today Rhianna Hoover and Christel Tham, who both serve as rapporteurs to the ICCA panel of experts. And they will be moderating the Q&A portion of today's event, where we hope to engage with questions from you in the audience. So again, a warm thank you to all of the panelists joining us for today's discussion. So I think we are ready to jump into the conversation and with our panelists. And we will start with our first topic, where we will look at the conciliation tool and compare it to other dispute resolution mechanisms. So if I turn to you first, Laurence, how do you perceive the role of conciliation? What role does it play in the current legal framework as a matter of general international law? Would you kindly share your views with us on that? So,
thanks. It's great to be with you today. First, I'm a professor of international law, as you've said, so it's going to be a bit legalistic, but you know, for resolving disputes in international law, we have two sorts of means: judiciary means and diplomatic means. And that means a judiciary mean it's a court, a tribunal, and the others are going to be diplomatic. So it's the states or a third actor, which is going to be diplomatic. So when we speak about conciliation, we speak about a means which is a diplomatic means, and it's I think the big difference with a judicial mean meaning a court or tribunal, that is that the outcome is not going to be binding. And so this is something I think which is important. The other feature that we should highlight for conciliation is that there's a lot of flexibility. So states can sort of model the procedure. And it's interesting to see that in the field of international environmental law, states, in fact, have favored conciliation. And there's been a study which has been done, and in about 9 multilateral environmental treaties, conciliation is identified as the default mechanism, meaning that if there is no other mechanism for settling a dispute, it's going to be conciliation. So I think that with this acknowledgement in conventional, in treaty practice, that conciliation is an important means, it means that for states, it has value. It has, and I think it's this flexibility which is at stake. Now, it is true that in practice, meaning dispute settlement practice, we don't have many cases, and we will discuss the cases that we have had. But it doesn't mean that there is no interest for conciliation. I think it's there, and states want to have it with them. And it seems to me that it is included in the climate change conventions for this purpose, because it was a diplomatic means which would offer flexibility. Now, the practice in environmental law, we have to remember that it's a new field of law, and we are managing collective interests. So for new issues, we need new types of mechanisms, and conciliation is one of them. Thank you.
Thank you, Laurence. I'll pick up on a few of the themes that you played out for us, including conciliation as a default mechanism, international environmental law, albeit not often invoked. So Makane, I want to turn over to you to really dig into that a bit. What advantages would you say that conciliation may have over other dispute resolution mechanisms? And how should we think about those advantages specifically in the context of climate change disputes?
Thank you, Catherine, and thank you for the invitation. Well, allow me to start by saying that I think that conciliation is the adequate mechanism for the settlement of climate disputes, and I make such an affirmation based on 3 reasons. First, conciliation is adapted to the objective underlying the settlement of climate disputes. Second, conciliation is adapted to the process that should guide the settlement of climate disputes. And third, conciliation is adapted to the very subject matter that often characterize climate disputes. So let me start first with the objective. As we all know, under the UNFCCC and the Paris Agreement, climate change is qualified as a common concern of humankind. And because it's a common concern of humankind, both the UNFCCC and the Paris Agreement call for widest possible cooperation and participation by all states in effective and appropriate international response. So widest possible cooperation and participation in an effective and appropriate international response. These objectives, in accordance with customary rules of treaty interpretation, should guide the settlement of climate disputes arising from the UNFCCC and the Paris Agreement. So what does it mean? It means that the settlement of climate disputes within the climate regime should lead to collaboration, to cooperation, and positive solution between the disputing parties. In other words, the settlement of climate disputes should not be seen as a contentious process where you would have the traditional winner-loser scenario that we find usually before international courts and tribunals, such as permanent courts or arbitral tribunals. And it means also that the settlement of climate disputes should not be based in principle on a confrontational approach. So conciliation has the highest potential to achieve this idea of cooperation, collaboration, and participation. Indeed, one of the main functions of conciliation is to encourage and structure a dialogue between disputing parties while providing them with an assistance that may be necessary to find a positive solution to their dispute. So this is the first reason why I said that conciliation is actually the adequate mechanism when we take into account the objective of the climate regime. Now let me come to the process. We know that the climate regime since the Paris Agreement is mostly based on what we call a bottom-up process. So states communicate nationally determined contribution, indicating what are their goals in terms of mitigation and adaptation. And here again, this means that the settlement of climate disputes, at least under the UNFCCC and the Paris Agreement, should reflect this process, this bottom-up process, and depart from a top-down approach, which usually characterizes the settlement of international disputes. Usually, settlement of disputes before international courts and tribunals, in particular permanent courts or arbitral tribunals, is very top-down, while here we know that the approach has to be bottom-up. So as Professor Boisson-Chazon was saying, we need flexibility. And conciliation, in my view, appears as the mechanism that is the most apt to take into account the bottom-up approach, and which would be more differential to a system based on nationally determined contribution. There are two features of conciliation that actually confirm this vision, this perception. Conciliation is here to define the terms of a settlement that is susceptible of being accepted by the disputing parties. And here we see the flexibility, we see something that is closer to bottom-up. And then a second feature is that conciliation affords the parties with assistance, with aid that they may have requested in view to reach a settlement. And again, I think that here we are more in a logic that is compatible with the bottom-up process. I come now to my third and last point, which is that conciliation is very much adequate, very much adapted to what I would call the subject matter of climate disputes. Climate disputes, they are not simply about legal issues. Most of the climate dispute raise complex technical, scientific, economic, and sometimes even socio-economic facts. And one advantage of conciliation is that it allows a conciliation commission to undertake what we can call an objective investigation and objective evaluation of all aspects of a dispute. So not just the legal elements, the legal aspects, but all the aspects, so even the extra legal elements. And this is what differentiates in particular conciliation and mediation. Mediation is not really based on an investigative process, while conciliation allows for that. And because conciliation allows for objective investigation, it is much more institutionalized, much more formal than mediation. And so it brings much more predictability in how climate disputes could be resolved, could be solved. So I think that that investigative dimension is very important when it comes to climate dispute, once again, because those disputes are not just reduced or limited to legal aspects. And because we can have this comprehensive objective investigation, what does it mean in fine? At the end of the day, is that conciliation allows to reach more equitable solutions. Climate disputes needs to take into account broad aspects, and so the settlement of those disputes have to be as equitable as possible, and conciliation, because of the features I've described, can really help to reach more equitable solution. And we know that equity is at the heart of the climate regime. Thank you.
Thank you so much, Makane, for this very, very thoughtful overview on sort of the advantages. You talked about the objective, if I may just briefly summarize, because I thought that, repeat, because I thought they were so valuable. I mean, on the objective of cooperation and collaboration in the climate change context, and the bottom-up approach that is so valuable. In particular, this is how the Paris Agreement is built. And then the content of these disputes can be such a wide variation of topics where we are looking for a process or procedure where you could have what you call the objective investigation. I think this is a very good term to describe it. So thank you so much for that. So we have heard now about the advantages, and we have heard about the role and the place of conciliation in international law. And so turning then to the question of the examples that we have in the practice of international law of successful conciliations in the past that may highlight some of these features, and also on the question what we can learn from these successful conciliations for the future. If I may turn to you, Toby, to explore some of these issues.
Well, thanks very much, Annette, and thanks to the entire panel for joining this morning. Good morning, good afternoon, wherever you are. Yeah, we, as Laurent said earlier, international environmental law is an emerging area of international law, so we don't have a richness of precedent for successful conciliations. But there are a few we can point to where I would say that the mechanism of conciliation and the flexible bottom-up approach that it delivered was critical to the resolution of some disputes. So the most obvious example is the Timor Sea conciliation, which was initiated in 2016 and led to a maritime delimitation treaty between Australia and Timor-Leste in 2018. That conciliation took place under the UN Convention on the Law of the Sea. Article 298 of the convention provides for compulsory conciliation in certain maritime delimitation cases where a state has opted out of other compulsory dispute resolution procedures. In 2016, Timor-Leste invoked the compulsory conciliation procedure to seek a peaceful resolution of its maritime boundary dispute with Australia. The shared resource-rich Timor Sea was a point of real dispute between those two states. The Conciliation Commission observed in its final report that both states started the conciliation with highly entrenched and conflicting legal positions, that in an ordinary dispute resolution procedure, arbitration or judicial determination would have led to a resolution of that dispute by identifying which state was the winner of that contesting legal argument. In the conciliation process, instead, a flexible mechanism was used which allowed the parties to shift away from their entrenched legal positions and find practical solutions. And the outcome was then described by the Commission as preferable to a resolution of the dispute consisting merely of identifying a winner. And it seems that both states were comfortable with the Maritime Delimitation Treaty that resulted from it. Another recent example, not in the international environmental law context, but certainly high profile, was successful conciliations carried out under the CERD Convention between Qatar and Saudi Arabia and Qatar and UAE. Article 12(1)(a) of the CERD Convention empowers the committee to establish an ad hoc conciliation commission to report on the dispute between parties to the convention. That conciliation mechanism had laid dormant under the CERD Convention for 50 years, but on the initiation of Qatar, those two conciliations allowed the highly contested issues in that case to be brought to a flexible mechanism where the parties were able to build trust, to have dialogue facilitated through a non-adversarial and flexible process. And not entirely because of the conciliation, but at least because of that important contributing factor that led to the Alula Declaration in January 2021. So I think what we have is we've got some recent examples of conciliations helping disputing parties come to a peaceful resolution of their disputes through consent, flexibility, and also through an adequate balancing of confidentiality and transparency interests. So one of the issues that we may come to talk about is the extent to which conciliation is a confidential process or a transparent process. Now, in both of those disputes, confidentiality was an important part of the process itself, but at the end of the process, there was a good degree of transparency about what had taken place and the outcome of the conciliation too. And in both of those examples, the conciliation process led to an amicable resolution of disputes.
Thank you very much, Toby. I want to build on the real world examples that Toby went through, including and especially I think the Timor Sea conciliation, which as you mentioned is really one of the most paradigmatic and successful examples of the use of the mechanism for purpose of a dispute. I also want to build a bit on what Makane has gone through about the flexibility of the procedure, the investigative dimension, as you mentioned, Makane, and the equitable aspects of it. And on that basis, Christopher, I'd like to turn to you and take advantage of your deep expertise in negotiations and the conduct of negotiations on behalf of states to ask you kind of the basic question, which is, what features, if any, of conciliation do you think can make states more willing to engage to resolve their disputes, and of course, in the particular context of climate change? Over to you.
Well, thank you very much, and a very good evening from Port Vila, Vanuatu, where we've just entered the rainy season, and we've come out of an absolutely torrential rain event, which has disrupted all of our economic activity in the city right now. What is very clear is that Vanuatu is out of time. The actions of states to address climate change is well beyond our capacity to cope. This is now an existential crisis for us. I mean, communities are literally wondering whether this month they're going to lose the last of their coral reefs, whether the cyclone, which is just around the corner, is going to wipe out all of their savings, village infrastructure, or whether the rising seas are finally going to erode their ancestral sacred sites. I mean, this is the level of crisis that we're facing. And while the UNFCCC negotiations are incredibly important, they are moving too slowly, and they do not match the reality of the loss and damage that so many of us are now experiencing. And of course, while there is this provision, both within the UNFCCC and the Paris Agreement for conciliation, it has not been used. And I think the reason is because there is a lack of clarity on the obligations of states which would underlie a formal dispute. And if you're following the negotiations which are happening right now in Baku, there is certainly mistrust, there is frustration, there is eroded cooperation, but there are no formal disputes, largely because of this nationally determined nature of climate contributions. But Vanuatu is leaving no stone unturned when it comes to encouraging states to address the climate crisis, including by resolving both formal and informal disputes and tackling these ongoing injustices. So, for example, Vanuatu has taken a case with COSIS to the International Tribunal of the Law of the Sea. We're also pushing to criminalize ecocide at the International Criminal Court in the Rome Statute Amendment. And of course, developing a new treaty, a fossil fuel non-proliferation treaty, which actually does include more formal obligations of states. But another one of the ways that Vanuatu is approaching climate dispute resolution has been by bringing an advisory case to the International Court of Justice. So this is, of course, one of the 6 principal organs of the United Nations, and the ICJ does settle disputes among and between states, but it also provides these advisory opinions on international legal issues, important ones, critical ones, like nuclearization, colonialism, self-determination, etc. And in our case to the ICJ, we've called on this advisory function of the court, specifically seeking clarification about what the obligations for states are, both under the UNFCCC and Paris Agreement, but more broadly under the corpus of international law, human rights law, etc. So we are very concerned that states and the disputes that states may raise are not being raised because there is a lack of clarity. We know, of course, that human rights law is universal and ambiguous, but what happens when human rights are violated because of climate change action? So this is the question that we're trying now to bring to the court, which then could help us in conciliation processes. So as you know, of course, this court case is well underway. From April of last year, written submissions have been made. And in fact, in just a couple of weeks, we will begin the final oral arguments. There will be 105 arguments made. 98 countries will be making those submissions, and Vanuatu, of course, will kick off the oral arguments on the 2nd of December. And I just want to be very clear that this case is not just about the Paris Agreement or the UNFCCC, but the advisory opinion really does look at a range of international laws, the Universal Declaration of Human Rights, the Covenant of Civil and Political Rights, the Law of the Sea, for example. And so we're hoping that this advisory opinion will then help us when we do enter into conciliation processes under the UNFCCC and the Paris Agreement to bring that much needed clarity. I think for conciliation, what's going to be really important is that we continue to provide opportunities to build trust. Right now, it is at an absolute low. We need more communication. We need relationship building. Really, we need to de-escalate some of the existential informal disputes that we're facing while building ambition at the same time. And Vanuatu absolutely hopes that we can avoid climate litigation and really follow this process of non-adversarial collective and cooperative approaches, which the Paris Agreement, the UNFCCC are built on. So we laud the efforts to develop this annex for procedures that could be adopted by the COP. And we hope that the advisory opinion will in fact help us by providing the clarity needed that when we do adopt these procedures, that states will have a very clear set of obligations, which they can then constructively engage in conciliation. Thank you.
Thank you so much. And I think it has escaped no one the amazing leading role that Vanuatu is taking in the use of international law in this very special point in time in human history. So thank you for that. I'd like to take the opportunity to say that you are sort of leading the way in that regard. And I think we are all following the ICJ procedures, not least with great interest. And we'll certainly pay much attention to the outcome there from the court. I wanted to go back when you said about sort of the building of trust, which is of course an extremely important element in this entire process. And do you think we should, and this is sort of a general question, do you think we need to highlight more from a general perspective the potential conciliation in general in international law and international relations? And we have heard from Toby some of the examples that may not be that well known outside the international law circles, but still could sort of instill a lot of positive and hope when it comes to international relations. Do you think should we do more to highlight the potential role of conciliation in general, to, for example, when it comes to building trust in complex international relations? If I may ask you, Chris, this is a curveball, so sorry about that.
No, I'm really glad you're asking this. So when it comes to the Paris Agreement and the NDCs, I think so many countries are very far off track from where we need to be, from where the science says we need to be, and of course, meeting our obligations under international law. And so I really do feel that a conciliation process could be built flexibly and to take into account the very complex, as we heard before, social and economic and political realities of countries, but really allow us to get to a process that is built on solving the climate crisis. And we need to talk about these NDCs. We need to have a conciliation process that's built from the ground up, essentially. Otherwise, we will never, ever address this global crisis that we're facing.
Thank you. So, of course, the topic for this discussion here now is the conciliation annex and sort of the types of situations that an annex could target when it comes to resolving disputes. But many of the in the audience will be familiar with the existing compliance mechanisms under the UNFCCC and the Paris Agreement. And I say compliance mechanisms, so that is something different from the draft annex and what the mechanisms foreseen in the draft annex. But maybe we should spend some time sort of explaining what are the differences between the two and how might they work together to progress global climate-related objectives. And is there any risk of overlap here? So if I may turn to you, Lawrence, to guide us on this topic.
Thanks. So we've been speaking a lot about conciliation, and rightly so. As we've said, it's one of the dispute settlement mechanisms, but it's one which is important, favored by states in environmental law. But aside from this mechanism of conciliation, which is attempting to resolve in an equitable manner disputes that may arise, the regime, the climate change regime, is providing for other type of mechanisms, which I would like to stress, they are mostly going to be monitoring the respect of the commitments of states under the Framework Convention and the Paris Agreement. And so I'd like to mention one procedure, which I think is important. It's the implementation and compliance procedure. But this, and there is a committee which is established. It's a committee which has already issued some decisions. But this committee is there to sort of monitor compliance with the instruments, the climate change instruments, and it's there to detect if there is a problem. So it's mostly dispute avoidance. It's trying to make sure that states are going to do what they're supposed to do, are complying with their obligations and so on. But it might be that, you have this compliance mechanism, but anyhow, there will be a problem. There will be a violation, there will be a breach of one of the commitments. And there comes what we call the dispute settlement mechanism, and among them the Conciliation Commission. So I think they're complementary. And they're all playing a very important role. As was said by the previous speakers, we're speaking of the management of a common concern of mankind. And we are all trying to do our best, not sufficiently, as was said, but we're trying to do our best to reach the objective as set by the Paris Agreement. And in certain situations, the Compliance Committee is not going to be able to make sure that states comply with their commitments. So then we will have to resort to dispute settlement mechanisms. And it has been said by the previous speakers, but conciliation is there and it's flexible. And maybe something we can go back to is that it's also confidential. So it's not something which is going to be publicized. The states are going to have mechanisms where they can resolve the disputes in a confidential manner, and with a lot of flexibility. So I'm all for flexibility. We should avoid disputes, but when disputes arise, conciliation is an important mechanism for settling the disputes. Thanks.
Thank you, Laurence. I want to pick up one of the aspects of conciliation, as you say, that's an important mechanism for the resolution of disputes. And that has to do with basically in the procedures of any proposed annex, how some of the equities are balanced. So an obvious one that we've talked about is, for example, when it comes to transparency versus confidentiality, there's different, obviously, merits to different aspects of the transparency in a public good dispute around climate change, at the same time affording parties confidentiality for the promotion of actual resolution of the dispute is important. So that's just one example of the work of the Blue Ribbon Panel in the sense of building out a potential draft conciliation annex. So with that, I want to turn back to you, Toby. Folks, for people interested in the project, you'll see some of the further description and detail at the website that's in the chat. But Toby, I wanted to ask you to take us into a bit of a deeper dive as to the different needs and circumstances of states parties to ensure equal access to conciliation and how that is played out, and how does the annex take into account some of these core equities in the resolution of disputes?
Thanks, Catherine. This takes the conversation from the general to the specific, and we're now really talking about what have we drafted as a panel, and what are we offering up to states. And I think that contextually for that, it's important to say that this is a draft annex. This reflects the collective expert view of the panel members, and we offer this annex up as a starting point, not an end point. This is ultimately something which, if it's going to come into force, it's going to come into force because states see this annex, they like what it's suggesting, and they take it on themselves and develop it how they wish. So we're offering this up in a spirit of humility to say, here is a starting point for states to look at what we've come up with and to work out how they would like to develop it with a view to making it a formal part of the UNFCCC and Paris Agreement. So your question was really about equitable access, and that's a really critical question in any dispute resolution mechanism. In climate change disputes, there are very likely to be significant imbalances of both human and financial capacity between the parties. And it was certainly on the minds of the panel members who were involved in drafting the annex to ensure that the mechanism that we came up with was one which would ensure that equitable access. Now, the starting point for that is that conciliation is generally more likely to be accessible than other forms of dispute resolution. It's not intended to be a highly legalized process. As Laurence indicated earlier, this is more in the diplomatic process mold than a legal process mold, though I would say it's a hybrid of the two. The conciliation procedures envisaged in the draft annex, they create opportunities for states to build trust, to increase communication, to look for practical solutions, to de-escalate differences. And this is less likely to require massively resourced specialized legal teams and more likely to be run by in-house legal teams from ministries of foreign affairs. In addition, though, the annex has some specific provisions which encourage equitable access. First, flexibility is key. In Article 1D, the disputing parties may agree to modify or exclude any of the articles in this annex at any time. So parties to a dispute which is referred to a conciliation commission can modify the procedure as they see fit by consent. Article 11A, the Commission is to conduct the conciliation taking into account the resources of the disputing parties. And Article 25B, costs are to be allocated based on considerations of fairness and equity. So there aren't any hard-edged rules saying how the resources of disputing parties should be taken into account or how costs must be allocated. But those are two key features that a conciliation commission will need to bear in mind and ensure is complied with to ensure fairness and equity through the process.
Thank you, Toby. And I just want to add and echo that this draft annex has really been developed by this Blue Ribbon panel in a spirit of humility to facilitate discussions by states. And of course, it's the states parties that must really take the lead and take the priority and frankly shape the process that fits the various state priorities and the equities that we've discussed. So for those that are interested in receiving the draft annex, please reach out to any one of these panelists, and we're happy to to provide it. And as we've been doing, engaging further with states parties in the context of the UN here at COP, to describe why some of the draft annex provisions have been put forward as recommendations. So before we open it to questions, I wanted to also kind of make the point that the draft annex will help not just in terms of disputes under the UNFCCC and the Paris Agreement, but really is really could be very critical in reaching beyond those instruments. And one particular development this year, in May of this year, I think puts a fine point on it. So for example, under Article 6 of the Paris Agreement, we've seen in May of this year, Sweden and Ghana reaching a binding agreement on emissions trading under the Paris Agreement. And interestingly, that agreement refers to UNFCCC Article 14. So to the extent that states parties are operationalizing Article 14 by actually negotiating a conciliation annex, you can imagine the repercussions and the domino effect of having it present as a dispute resolution option, a meaningful one with procedures spelled out in greater context beyond just those two regimes. So a lot of, I think, power and potential in the concept of conciliation when it comes to climate change disputes. So with that, let me turn it over to our remarkable rapporteurs. We have Christel, Tham, and Rhianna Hoover, who are going to moderate the discussion. I see some questions coming in through the chat function. So over to you.
Great, thanks, Catherine. Yeah, we've got some great questions from the audience, and Christel and I will have some questions as well. So I'll start with two from Irene and Anna. Thank you for sending these in. Considering the current state of global climate negotiations, what specific strategies might be employed to foster conciliation among nations, especially with varying economic priorities, to ensure equitable contributions towards climate action? And the second is, in light of diverse approaches to climate mitigation and adaptation, how can we strengthen cross-sectoral partnerships and promote conciliatory mechanisms that bridge policy and practical implementation gaps?
So I think I'm happy for the rapporteurs to tap anyone, but on the strategies, Christopher, did you want to tap in on that one as with given your experience in negotiation? What would you say about the strategies question?
That's a really interesting one. And we heard previously that most of the mechanisms, the compliance mechanisms, focus on monitoring, right? So a nation, a party would produce their nationally determined contribution. They would make certain self-determined commitments to the Paris Agreement. And then it's about monitoring whether the country fulfills those agreements. I think a strategy question is about, are those commitments adequate in the first place? Not whether they're met, but whether they're adequate in the first place to meet the goals of the UNFCCC and the Paris Agreement, the temperature goal, the finance goal, et cetera. And so I think conciliation could actually be used to question the adequacy of those NDCs in the first place. And I would think once we have some clarity on obligations, that this would be one of the first uses of the conciliation mechanism, is for one state to question the assumptions of the NDC in the first place of another country. And that process could be done flexibly. It could encourage dialogue, and it could be built on the situations of the two countries involved, or two or more countries. But I think this could be a really important strategy to say, are we producing NDCs that are actually going to get us past this climate crisis or not?
Toby, do you want to take it from there? I see your hand up.
Yeah, thanks very much for the question. I'm not sure that I'm going to directly answer the question, but it prompts me to think about another aspect of the Draft Conciliation Annex that's important, which is that we've been talking about conciliation as a mechanism for dispute resolution. And we tend to think about dispute resolution as a bilateral issue where there are two disputing parties. But the issue that's raised in this question is a good example of where the resolution of these kinds of disputes are very likely not to be bilateral. They're very likely to involve more than two parties. And the Conciliation Annex provides a mechanism for multi-party disputes to be resolved through conciliation. And it also provides for the possibility of third parties making contributions to the conciliation. So there wouldn't be third parties coming in and joining a multi-party interstate dispute, but third parties, civil society, NGOs, would have an opportunity, subject to the consent of the parties, to contribute to the resolution of that dispute through the conciliation process. And the kind of dispute that's raised in this question is exactly the kind of dispute that may well benefit from multi-party conciliation with third-party interventions.
Great, thank you. Makane, did you have anything to add?
Yes, thank you, Rhianna. I just wanted to jump back on one aspect of the question that has been asked, which is how do we achieve equitable solutions? And I think that was one aspect I mentioned in my intervention earlier on, that conciliation is about achieving mutually acceptable solutions. If we want to think about climate action in terms of equitable initiatives, equitable strategies, we need to guarantee some sort of equity in the process of the settlement of climate disputes. And I think that conciliation really has this advantage of promoting win-win solutions, a winner-winner scenario, and not a winner-loser scenario. And I'm rather convinced that actually conciliation is also the best way to achieve or to implement CBDR, common but differentiated responsibilities in light of different national circumstances. It can really allow to take into account different national circumstances and lead to adapted and acceptable solutions. Thank you.
If I could just add one comment to that, I completely agree with everything said. And I think it has, Rhianna, to do with the second question you asked about diverse approaches to climate mitigation adaptation and how you bridge policy and practical implementation gaps. And I think part of that, and Makane and Toby have said this, as did Laurence and Christopher, all of us have focused really on the flexibility of the mechanism. And one particular aspect of the flexibility that would allow for exactly that cross-sectoral partnership and policy and practice implementation gaps is the ability to bring in technical evidence, technical expertise in a way that isn't overly circumscribed to the legal parameters of a dispute that tends to occur in more contentious processes. So the Timor-Leste conciliation process, I think, really evidenced this in the sense that those parties in that process could take account not just the legal aspects of a dispute in a contentious context, but expand it out and bring the technical information to address the larger policy, larger practical implementation gaps. So it is very much quite a powerful tool, and far more powerful in the context of climate change, where technical and other aspects become so important, so central to finding a solution to that win-win that Makane is talking about. So I just wanted to add that as well in that second question. Thank you.
Great, thank you, everyone. So the next question, I think, Toby, you may be best placed to answer this. What is the role of third-party funding in conciliation proceedings, if any, and is there a role for it in climate change disputes specifically?
That's a really interesting question. I mean, let me focus on the conciliation aspect. When I spoke about equitable access and the way in which the Conciliation Annex attempts to ensure that financial burdens of conciliation are taken into account and costs are shared equitably, I suggested that participation in conciliation is more likely to be less burdensome financially than in other dispute resolution mechanisms, but it is inevitably a process that will impose significant costs on states that participate. Now, third-party funding to states involved in conciliation is unusual, but it's certainly a possibility. And then, to the extent that third parties, NGOs, civil society participate in a conciliation process, there's the possibility of third-party funding there. I mean, this would almost inevitably be philanthropic funding, because third-party funding of litigation is often driven by a commercial incentive, and this is unlikely to be the kind of dispute resolution mechanism where there would be a commercial incentive to provide that third-party funding, but philanthropic funding certainly.
Thanks, Toby. Moving on to the next question, I think maybe this is for Chris or Laurence. You mentioned, Chris, that because of the nature of nationally determined contributions and NDCs, there haven't been any formal disputes of late. Laurence, you mentioned the existence of dispute avoidance mechanisms that are embedded in the UNFCCC framework. In the context of this, do you foresee there being more interstate disputes or formal disputes in the climate change context going forward? I know, Chris, you mentioned, particularly from the perspective of Vanuatu, trying to explore every avenue possible to pursue the climate goals that Vanuatu has. And in that context, you've been thinking about, you talking about challenging the states' NDCs and formal disputes, but potentially coming out of that. So do you foresee there being more disputes in that?
Yeah, I can take a first answer, and then maybe the others can complement. But I think that we are now, we've been in the phase of negotiating. We've been in the first phase with the national commitments, and then now we are saying that, in fact, it's not sufficient. It's not sufficient. The objective of the Paris Agreement will not be reached, and so on. So I think there will be more and more attention to what states do, and it might be that there will be disputes around this, but not just interstate disputes. I think that there will also be cases brought before domestic courts and so on. But in this context, I think that the conciliation has some virtue, because it has been said and repeated, but it's a warning system. So it's based on consent. The states come and they exchange. And maybe something I'd like to add to all the advantages is that it's equality of rights for the two parties or the three parties or the group of states who are there, because they have the same rights in terms of making their case and being heard. And I think this is very important, because it's a procedure which is grounded on justice, on the rule of law. And so I think there are a lot of potentialities. It's not that I think we should be looking for disputes, because hopefully states will do what they're supposed to do. But it seems to me that there are going to be a lot of tensions in the coming years, because we're not doing what we should be doing. That's for sure. I don't know if others want to add anything on this.
Thank you, Laurence. That was really helpful. Thank you. Moving on.
I think Toby had his hand up. Sorry.
Sorry, Toby. Hi.
Thanks, Christel. Yeah, I mean, I would just endorse what Laurence has said. Climate change disputes are not going away. I think if you look across the field in domestic litigation, in international arbitration, in looking at the ICJ advisory opinion, the ITLOS advisory opinion, I think all of this presages increasing climate change disputes. And I think if you look at some of the submissions that are being made in relation to Part B of the question to the International Court of Justice, presages disputes in relation to loss and damage, and those are interstate disputes. So I think the Conciliation Annex provides a very good mechanism for those disputes to be resolved at reasonable cost, with equitable access, with flexibility, and in a cooperative, collaborative manner, which is consistent with the duty to cooperate that underpins the Paris Agreement and underpins international environmental law.
Thanks, Toby. That's actually a great segue to our next question, which, in talking about the diversity of disputes that you expect to arise in the future, is there a potential for conciliation to play a role in the settlement of climate change related disputes outside of the UNFCCC framework and multilateral environmental agreements, perhaps including in the national, public, private, or transnational context? Maybe that's back to Toby, but I open it up to the floor in case anyone wants to chime in as well.
I think Christopher and Makane have their hands up.
Maybe I'll jump
Chris,
in
you
first.
wanna jump in?
Yeah, I really think there is going to be an increase now in looking at the cross linkages with the climate crisis and other obligations to protect people, the environment, society. I think what we're going to start to see are parties and non-party stakeholders raising not just what parties are doing in their NDCs, but what they're omitting to do, what they're not doing, which they must do. And I feel like this conciliation can play quite a constructive role. Specifically, I'm thinking about the cross-sectoral nature of human rights. Human rights is in the preamble of the Paris Agreement that all parties will uphold the rule of law when it comes to human rights. I'm also thinking about some of the finance obligations around 2.1c. This is aligning financial flows with the temperature goal, 1.5 degrees. And so these are spaces, I think, where conciliation processes can really get at the heart of what's not being done, what parties are not doing when it comes to meeting the obligations of the Paris Agreement and UNFCCC.
Before the next speaker jumps in, I would just like to say we have about 8 minutes left in the session. So we would like some time to conclude and thank our speakers, if our speakers keep that in mind. Thank you.
Yeah, I think maybe we can go to Makane and see if we have time left for one last question.
Yes. Thank you, Christel. No, I just wanted to say that there is today appetite for mechanisms such as conciliation when it comes to the settlement of climate disputes beyond the climate change regime, beyond the UNFCCC and the Paris Agreement. Let's not forget that the IPCC, in its last report, its sixth assessment report, has actually criticized investment arbitration as a proper tool to settle climate disputes. There is a very strong criticism in that report that ISDS, Investor State Dispute Settlement, in its arbitration form is problematic. Even David Boyd, the UN Special Rapporteur on the right to a healthy environment, last year has published a report entitled, I think, the catastrophic consequences of investor-state dispute settlement on climate action, and the major criticism is investment arbitration. So there is a call to look for other mechanisms, less confrontational, when it comes to climate disputes, not only interstate ones, but also disputes that may arise between foreign investors and host states. And we are having now a new generation of investment agreements that are containing climate change provisions. I'm speaking, for instance, from the African experience. We have now an investment protocol since 2023 in Africa for the African Continental Free Trade Area that contains rules on investment and climate change. And in the current discussions in Africa regarding the settlement of investment disputes, states are wondering what are the appropriate mechanisms to settle, for instance, investment disputes related to climate issues, and conciliation is one of the mechanisms that is being contemplated. So any achievement that would be made at the level of the UNFCCC and Paris Agreement will cross-fertilize in the system and help for more comprehensive and systemic settlement of climate disputes.
Great, thank you, Makane. I think we'll end with one final question from Shmuel Yerushalmi. How might the resolution of climate change disputes through this equitable, justice-based mechanism like conciliation support the resolution of other conflicts, political and military conflicts around the world, if at all? Laurence, I see you smiling. Do you want to take this one?
Yeah, it's a difficult question. What I would say is that everything is linked, and a lot of the climate impacts have caused all the sorts of tensions and military conflicts, that's for sure. So when we come to a military conflict, I don't know, maybe if we should use all the mechanisms that we have at hand, and conciliation is one. There are others. There too, I don't think there is any exclusivity, but it seems to me that conciliation, like for the other panelists, is well suited for the type of disputes that we have in the context of climate change.
Great, thank you. And we'll pass it back to you, Catherine, to close us out.
Well, thank you. Thank you, Rhianna. Thank you, Christel, for the excellent moderation. I think just taking it back and leaving some time for the conclusion, I will say that it is really, I think, staggering, the idea that where we are now in the climate conversation and the urgency and the existential threat that it poses, the idea that we wouldn't bring to bear an all-tools approach, and that the conciliation annex that's in the UNFCCC and the Paris Agreement is left on the table doesn't seem to be tolerable anymore. And of course, states parties have had amazing and remarkable progress in the context of the Paris Agreement, including in prioritizing other aspects that make complete sense, and climate finance being among them. But at this stage, at this juncture, it seems that the conciliation annex, the idea of dispute resolution that's effective, that's cross-sectorial, that is equitable, that is flexible, that can bring in all of these different aspects of climate change disputes, needs to really be brought to the front burner of political priority. And so I think that's really the core of the work of this Blue Ribbon panel, and obviously, again, there with humility to assist states parties in taking it forward. So I'll end there and hand it back over to our wonderful conveners for their final comments. Thank you.
Watched.
Wonderful.
You're in an
Thank you so
incredibly
much.
important space at the
Thanks
moment.
all of our
In
speakers,
books that we did
chairs,
with Oxford
discussants,
University Press
our
a couple of
moderators,
years ago,
everyone who sort of
we
helped
lay
guide me
out
stay
an
successful.
agenda. It's called
There
Athena's
will be a
Treaties,
recording of this
because
available
when we
after
looked
today.
at it, we discovered that
And,
the ancient
yeah, I
Greek
hope that
god
wherever, lovely
trade,
evening,
actually
afternoon for you.
Hermes,
I hope you have a
was
wonderful
also
rest of your
the
day.
Greek god of
And we will be in
thieves.
touch soon.
And so we
Thank you
want
very
to
much.
reconsider how a trade and investment agreement might look